Hello Mousers! Today the Wheel of Thursday has spun round and it's come up with answer a question from a viewer. So that's what we're doing. Viewer Jody Curtis has asked, would you be willing to look into the TV licence legislation, whether watching TV online constitutes breach that would legally hold up in court, and where what is and isn't live TV is defined? Whether the TV licence contravenes any other legislation, as I thought initially your equipment had to be primarily for the purpose of watching live TV, and the TV licence now claims that you need a licence to watch TV, which is different to my original understanding of the law. This is a very interesting topic. It's something that comes up an awful lot because for many years, in fact since the TV licence came in, it's always been the definition that if you had a TV set, you had to have a licence to have it. And the same way that if you have a dog, you have to have a dog licence, that kind of thing. But legislation came in that changed this, and it came in because of live streaming on the internet and on mobile phones and things like that. So, let's have a look at what BBC iPlayer says. iPlayer being, for those of you who are outside the UK, the main way that people view television online because it's the BBC's own streaming service. So let's have a look at what they say about the TV licence. According to iPlayer, you do not need a television licence to catch up on television programmes in BBC iPlayer, only when you watch or record at the same time, or virtually the same time, as it is being broadcast, or otherwise distributed to the public. So, according to BBC iPlayer, if you're watching something as it's going out, or, and I looked this up, virtually the same time means within 2 hours of it going out, then you require a TV licence. But if it's on their streaming later service, which is what the majority of iPlayer actually is, you don't need a TV licence, because that is not contained within the remit of the law. And the BBC goes on to say that if viewing habits change to the point where the majority of people were not watching TV, or were not watching TV as it was put out, and instead we're waiting for after that time limit to come up and then watching it on iPlayer, then they might petition the government to change the legislation, but as it stands, they haven't. So, the current legislation is the legislation that was in effect when that statement was put up on the iPlayer website. But where does this statement come from? Well, its basis is the Communications Act 2003. Let's have a look at what that says. According to the Communications Act 2003, Section 363, subsection 1, a television receiver must not be installed or used unless the installation and use of the receiver is authorised by a licence under this part. But what is a television receiver? Well, Section 368 thankfully gives us a bit of information. Section 368, meanings of television receiver and use. Subsection 1. In this part, television receiver means any apparatus of a description specified in regulations made by the Secretary of State, setting out the descriptions of apparatus that are to be television receivers for the purposes of this part. Subsection 2. Regulations under this section defining a television receiver may provide for references to such a receiver to include references to software used in association with apparatus. Now, apparatus is basically equipment, and we know that, but this doesn't actually tell us what is defined as a television receiver. For that, we have to look at what the Secretary of State has said, and it took him until the Communications Television Licensing Regulations 2004 to actually explain this. So, what's he got to say? Part 3 of the regulations is on definitions for the purposes of the Communications Act 2003 and the Wireless Telegraphy Act of 1967. Section 9, subsection 1, television receiver means any apparatus installed or used for the purpose of receiving any television program service, whether or not it is installed for any other purpose. Subsection 2, reference to receiving a television program service includes receiving by any means any program included in that service, where that program is received at the same time or virtually the same time as it is broadcast. And as I said earlier, virtually the same time is within 2 hours. Now, the BBC used to do an interesting thing where it wouldn't allow programs to appear on iPlayer until an hour after they've been broadcast. So that used to be a kind of, well, it's not virtually the same time anymore, but they've got rid of that now. And not only can you now stream at the same time, but you can stream almost immediately after a program has been broadcast. So you've got to be really on the ball when it comes to virtually at the same time if you're not wanting to pay the TV licence. You've got to wait 2 hours, effectively, just to make sure that you're on the safe side. So there you have it. The Communications Act 2003 and the Communications Television Licensing Regulations of 2004 do allow the BBC to charge a TV licence for iPlayer, but only when you're watching live streams or what they call simulcasts or you're watching within 2 hours of the programme being broadcast. Anything outside of that, you can watch without having to have a TV licence, which is all fair and good if that's what you want to do. So, I hope that's cleared up your question, and that's all I've got time for today. So, thank you very much for watching. If you like this video, don't forget to click the like button, share it with your friends so that they know how to get around the TV licence as well, and subscribe so you get further videos in the future. Until next time, I've been Kirk-Robinson, you've been watching a video, and I'll see you tomorrow.